Hey, Brian Parker here with another exciting adventure. This hopefully won't be a snoozer, but this is about, well, even the title should wake you up, but destroying affidavits in collection cases. So we've been analyzing a lot of the documents that collection companies and creditors use to support their cases against you. Support is another relative term. But today we're going to talk about the document as it is, the affidavit. So we also talk about very commonly in our battles against the collector or creditor about the counter affidavit. Well, what are we countering? Well, yeah, we're countering their information, but a majority of the time we're countering an affidavit of theirs. We're using a counter affidavit. So that counter affidavit comes in many shapes and forms. But today we're going to look at their shape and their form and their shape shifters, because they can just shape them the way they want them. They can be advocating one position and on a dime change completely in a sworn affidavit. So let's look at how we can attack their sworn affidavits, and we're going to talk about it through the prism from the concept, from the context of hearsay. What is hearsay? Let's put it up. Hearsay, by the way, is really about reliability and credibility. The thing that's being said, spoken, brought in, testified to, the person that is advocating the position or saying the statement has to be credible, has to be trustworthy. And that is the same information and analysis that we look, whether it's written word or a spoken word. Remember, and I've got a great way to look at this. This is actually going to be a full video. I'm going to give you an intro video, and then if you want the full video, the great stuff, that will be on killdebt.com along with the documents. So we got to remember that in analyzing hearsay, I want you to remember the who, what, why, when, and where rule. That's how we figure out if something is coming in because it's an exception or staying out generally because it is hearsay. So hearsay is the following, Shazam, an out-of-court statement offered to prove the truth of the matter asserted. An out-of-court statement offered to prove the truth of what is being stated, an out-of-court statement. So you are looking at everything as hearsay. Hearsay, everything's hearsay, right? So the only way stuff comes in, evidence, comes in at trial or through an affidavit is if it meets an exception to the hearsay rule. General rule is everything is hearsay. Exception, we have to find, or they have to find an exception to bring in whatever bad stuff they're making up to use against us. So I'll give you a couple of exceptions to the hearsay rule. So generally, FRE 801 is the hearsay rule. An out-of-court statement offered to prove the truth of the matter asserted, whatever said, is not coming in. It's hearsay. The exception to that, and that's FRE 801, the exception to that are the following 6. Let's put up the following 6. The present sense exception, 8031, a statement describing or explaining event immediately after it occurs. Why? The immediately means we haven't had time for reflection or to make stuff up or to have a bad memory and go, yeah, I think it was. If it immediately happens and it's stated, then it's a present sense. Oh, he just killed that guy. That would be a present sense exception, all right? Because we know he didn't have time to make up because he hated that guy. And he goes, I think I'm going to tell people that he did it. So the excited utterance is similar, which is 8032, a statement made under stress of excitement caused by a startling event. Oh my God, Bob, I know Bob. He just robbed the bank right in front of me. That's excited utterance, similar to the present sense exception, I guess. 8034, statements of medical diagnosis. Statements made to a doctor for purposes of diagnosis and treatment. So remember, if it's credible and reliable, we're going to give it some weight if it's hearsay, but we want to find an exception. You don't go to a doctor with a bad leg and say, my arm hurts. You say, you're truthful. You want a diagnosis and a fix. We all do, right? So anything you're telling a doctor is generally going to be for the purposes of medical diagnosis. I want this thing fixed. I want this thing cut out of me. I'm not going to lie to the doctor. So we say it's credible. It meets the exception of statements of medical diagnosis. Business records. That's the one we're focusing on today, 8036. No matter what state you're in, it's usually some form of 8036. It's the business records exception. So everything is hearsay. There's a small window under the business records exceptions. However, courts, unfortunately, and most plaintiffs bringing stuff in think it's a giant chasm, a huge hole that you can just drive anything through. That's false. But judges can be lazy, if you will, but you gotta just remember, the rule is everything is hearsay. An exception is, it's an exception. It's 99 times out of 10 you can't do that, but an exception to the rule, right? So what's happening is more and more I see courts are making the exception swallow the rule. So the rule doesn't exist anymore. Stuff's just coming under what's called the business records exception. Records made in the regular course of business, kept routinely and based on personal knowledge. That's the key right there, right? Personal knowledge. Focus on that. Admissions by a party opponent, FRE 801D2, a statement made by the opposing party that can be used against them. And I've used that in trial. They go, oh, he says hearsay, admissions by a party opponent. That's the guy who said it, and we're suing him, or he's suing us. So admissions by opposing party, we want to bring in their own words against them. It's pretty reliable. They said it, especially if it's good for us. So former testimony. So testimony under oath at a prior proceeding where the party had an opportunity to cross-examine the witness. So if you have a transcript and it's of a previous setting, a court setting or deposition, we allow that to come in because both sides had a moment or a time to attack whatever was said or support what was said. It went through, if you will, a legal due diligence. And so we know it said, it was done, sworn under oath. Sorry, it's this one. So that's coming in under former testimony. There are exceptions to the exceptions. Don't worry about it. So we want to prove today, right now, that a person has bad breath in a witness testimony. So we say a guy comes in and before the hearsay objection in court, he's up there and we're trying to prove that this guy has bad breath. And he said that she said that he's got halitosis. So we're trying to prove this remote person said that this other guy has bad breath. So let me help you out here. So, and I'm going to make you go through the salient analysis so you can use the analysis of any kind of hearsay. So let's put up, he said that she said that he has halitosis. Now, the out of court statement analysis. So let's first, he said, Shazam. This refers to a statement made outside of court by a person not currently testifying. So the guy that is testifying, he or she heard that other person talk about the other guy's bad breath, right? So this is the out of court statement. Shazam, she said, is a further repetition of what is allegedly told to the first person, making an additional out of court statement. If you want to be technical and sound like a lawyer, you say, Your Honor, that's hearsay upon hearsay. So that's many levels of hearsay, but the best line is it's hearsay upon hearsay. When you say that, you're telling the other side, not only have you got to prove that there's an exception to this hearsay, now you got to prove there's an exception to another layer of hearsay, hearsay upon hearsay. So Shazam, the statement relied upon is that the person has halitosis. That's why the guy's up there talking about his bad breath, which is a claim about the person's condition, a bad breath. It's hearsay because it's an out-of-court statement offered to prove the truth of the matter asserted. So how do you get around that? This is funny because it's based on what we just talked about. The present sense exception, okay? So let's put up the present sense exception. A present sense exception is a statement made while observing an event or condition is describing or explaining it. The idea is that the statement is made while the event is happening. So time is an asset as far as exceptions, meaning if you report on something immediately after it happens, there's no time delay where memory or you didn't have glasses or a witness reflection, all that stuff is a killer for exception. So if you have a present sense exception, it's more likely to be reliable. Example, if she, let's put this up example, if she smells the bad breath and immediately says, he has halitosis, I don't know anyone that says someone has halitosis, they go, ugh, or they go, he has bad breath, while still processing the strong odor. So she yells, oh, he has halitosis. This would qualify as a present sense expression because it's describing what she's perceiving in real time. Remember, time is the enemy of exceptions. Time is the enemy of exceptions. So if it's a present sense exception where she exclaims it the minute it happens, oh, he's got halitosis, and if he repeats it, because it's a hearsay upon hearsay, okay, let's put that up there for the he repeats what she said, he has halitosis, immediately after hearing or observing the condition, this could still qualify. So she says, he's got halitosis, and immediately the guy goes, she said that he's got halitosis. It's present sense, sense being this, sense in a different way. I mean, using one of your senses, obviously, to smell, but it's the present sense expression, meaning that's what I exhibited, that's what I experienced right away. So I'm being silly here. We're analyzing written hearsay today from collection lawsuit affidavits. When analyzing affidavits, I want you to think of the hunter-gatherer. Does the affiant that is swearing under oath, and sometimes they're not, but is the affiant saying how they located the records? Usually this is a support or litigation specialist. Or are they saying how the records were created? So when you analyze these peripherally at first blanch, are they saying how they gathered the evidence or how they created the evidence? If you're saying how you created the evidence, you are more likely to meet the business records exception because you have what the most important thing, personal knowledge. So everything is hearsay until you get that wonderful exception. So we are going to look at what makes up the business record exception. Let's put it up. 8036, Shazam. It's number one, it's got to be made at or near the time. The record must be created close to the event it describes. Similar to what we're talking about with the present sense exception. Remember, time is the enemy of an exception. It's a good line. By someone with knowledge. The record must be made, remember, not reported on, but made by someone who knows the facts. Firsthand, not by someone guessing or just putting stuff together. Kept in the regular course of business. The record must be something that the business does normally. Why? Because it's called the business records exceptions, all right? So it must be something the business does all the time and not do because you're suing them and they quickly put something together, right? It must be something they normally did before the lawsuit occurred, if you will. It's the regular practice to make and keep these records. The business must have a habitual process. In other forms of evidence, we can never use something against someone. Oh, that guy has stolen a whole bunch of cars. Was this car stolen by him? Yeah, because he steals stuff all the time, and he's got 12 convictions for it. Now, if he had a habit, we can bring it in. If it's us besmirching his character based on his past stuff that has nothing to do with the facts of the case we're in, now we got a problem. But habit always usurps the exclusion of character evidence. So, oh boy, did I go deep there. The business must have a habitual process for making and keeping these records, showing it's part of how the business operates. They didn't just make stuff up just to win a case. So let's do this. The FRE business record exception, a custodian or another qualified witness who can establish the foundation requirement. So it must be a custodian of records, not a support specialist as you see in a lot of affidavits, or litigation specialist, something like that. So The best approach to this. Here are my tips, Parker tips for this part of the video. And let's go. Parker tips. Number one, you can show that an affidavit was created for litigation purposes. It's out. The date of the affidavit, if it's created after litigation started, that's already hearsay on hearsay out. Title of the affiant. If the person's a support coordinator or litigation specialist, they're not a custodian of the records that the rule requires. Number four, does the affidavit establish the records were made at or near the time or from other information? Five, are the documents referred to in the affidavit not attached to the affidavit? I see that all the time, and I'm going to show you in the full video where they literally said, according to the attached documents, and there were no attached documents. So you tell the court that, Your Honor, if you have those documents in front of you, I'll just fall on my sword. They never do, but you want them to play that theater role. Does the affiant have training at the company it speaks for? What do I mean by that? You'll be surprised how many times I depose an affiant, and let's say it's Velocity Investments. This actually happened. I'll go, oh, how long have you worked at Velocity Investments? Well, I actually work for Velocity Group Therapy, blah, 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 blah. Oh, so you don't work for the investment company? Yeah, but they wanted me to take a look. So you don't work, they asked you to take a look, so you didn't create the documents? That's correct. Goodbye, good night, nurse. Does the affiant have the training of a custodian of records or support specialist? Training is everything, especially when you are looking at, if I'm LVNV Funding and I'm saying, hey, we got the records from SoFi, as we're going to show today, 2023 personal loan, you must have training to know how they gathered their documents, Hunter Trainer, Hunter Gaviner. So if they haven't trained on that, they can't talk about that. So you will commonly see an affidavit attached to either a lawsuit or the final sword coming after you, which is the motion for summary disposition. So this video will tell you what to do in either instance, how to knock out their most important document after their claimed bill of sale. So we're going to look at this full video today, and the full video will have me analyzing for you so you can use it and kill their case from LVNV Funding, from Velocity Investments, and from Discover Accredited. I'm going to show you 3 affidavits on how to knock them out, and at the end I'm going to give you the why, what, where, how and when or why. This is great little tips for you to use at the end of the full video. So I hope you stick around at killdebt.com, powered by the AI of it all, Parker GPT.